And we are now on the prosecution pillar. This is the second component of the Philippine criminal justice system. And what is meant by the word prosecute? Well, it means to officially accuse someone of committing a crime in a law court, or of a lawyer to try to prove that the person accused of committing a crime is guilty of that crime. So in criminal case, it's actually a process by which formal criminal charges are brought against a person accused of committing a crime. So in prosecution pillar, it actually designates the government as the party to the proceeding in a criminal action. What is the prosecution pillar? What is the prosecution as a pillar of the criminal justice system? Well, a proceeding instituted and carried on by due course of law before a competent tribunal for the purpose of determining the guilt or innocence of a person charged of crime. And we have here the Presidential Decree number 1275 entitled Reorganizing the Prosecution Staff of the DOJ and the offices of the provincial and city fiscals regionalizing the prosecution service, and this law was enacted on April 11, 1978. So prosecution is actually a legal proceeding initiated and conducted through proper legal channels before a competent tribunal, typically a court. And the prosecution is basically responsible for building a case against the offender. And who are the prosecutors? These are quasi-judicial officer who assumes full discretion and represents the government or the people of the Philippines in a criminal proceeding before a court of law. And this role involves making crucial decisions during legal proceedings, such as deciding whether to file charges, presenting evidence, examining witnesses, and advocating for the government's case. And who must prosecute criminal actions? Well, all criminal actions, either commenced by complaint or by information, shall be prosecuted under the direction and control of a public prosecutor. So, here are the duties of a prosecutor. The function of a prosecutor is to initiate and prosecute all criminal prosecutions, actively involved in the investigation of crime, and can commence an investigation upon receiving a report from a law enforcement agency or a private party. So the role of a prosecutor is to start and handle criminal cases. So they're actively engaged in investigating crimes and can launch an investigation based on reports from law enforcement or private individuals. Essentially, prosecutors work to ensure that legal actions are taken against individuals accused of committing crimes, and they play a key part in the entire process from investigation to presenting the case in court. And also, another duty of a prosecutor is to verify whether the person arrested should be placed under the criminal justice process. It is his duty to protect the innocent from hasty, expensive, and useless trial. The individual in question is responsible for determining whether a person who has been arrested should be placed under the CJP. So this entails a careful verification process to assess the necessity of detaining the individual before their trial. Additionally, part of the duty involves safeguarding the right of innocent individuals by preventing costly and unnecessary trials. And another one, it's to conduct preliminary investigation. So one of the primary responsibilities of prosecutor is to conduct PI. So it's an essential step in the legal process where prosecutor assess the available evidence to determine if there is sufficient basis to file formal charges against a suspect. So it helps in establishing whether a crime has indeed been committed and if there is probable cause to proceed with a case. Second one would be to make proper recommendation during inquest proceedings of a case referred to them by the police after the investigation of the suspect. So, in cases referred by the police after an initial investigation of a suspect, the prosecutor is involved in inquest proceeding. So, this includes making informed recommendations about the appropriate legal actions to be taken, considering the evidence and circumstances surrounding the case. And inquest proceedings are often conducted promptly, especially when immediate legal action is required. The third one would be to represent the government or state during the prosecution of a case against the accused. Prosecutors, they play a crucial role in representing the government or state during the formal prosecution of a case. So this involves presenting evidence, examining witnesses, and arguing legal points to secure a fair and just resolution in court. And fourth one, to act as a legal officer of the province or city in the absence of its legal officer. So this includes providing legal advice, handling legal matters, and fulfilling the duties typically carried out by legal officers. So it ensures continuity in legal services even when the designated officer is unavailable. Fifth one, to investigate admin cases filed against state prosecutors, provincial, including the support staff. So prosecutors are also involved in investigating admin cases filed against state prosecutors, provincial, their support staff within the NPS. This internal oversight helps maintain professional standards within the prosecution service, addressing any allegations of misconduct and ensuring accountability. And we have RA number 171. It is known as the Prosecution Service Act of 2010, and this law was enacted to strengthen and rationalize the National Prosecution Service. And we have the National Prosecution Service. This is the official prosecutorial agency of the Philippines. So we have here the National Prosecution Service is divided into 4 levels. We have the prosecution staff headed by Prosecutor General, which is under the office of the Secretary of Justice. We have the regional prosecution offices headed by regional prosecutors, the office of the provincial prosecutors, and the office of the city prosecutors. And we have here a question: what is the primary responsibility of National Prosecution Service? Well, it is primarily responsible for the preliminary investigation and prosecution of all cases involving violations of penal laws under the supervision of the Secretary of Justice. And the prosecution staff, here are the duties: assist the Secretary of Justice in the exercise of his or her appellate jurisdiction, conduct PI and prosecution of criminal cases involving the national security, act as counsel for the people of the Philippines, investigate administrative charges against prosecutors, prepare legal opinions and queries involving violations of the RPC and special penal laws, and monitor all criminal cases filed with the Office of the Prosecutor General. And here are the functions of the regional prosecution: implement policies, plans, programs, memoranda, orders, circulars, and rules and regulations of the DOJ relative to the investigation and prosecution of the criminal cases in his or her region, exercise immediate admin supervision over all provincial and city prosecutors and other prosecuting officers for provinces and cities comprised within his or her region. Third one is to prosecute any case arising within the region. Fourth, when so delegated by the Secretary of Justice. Fifth, it's to designate a prosecutor from any office of the provincial or city prosecutor. And last one, with respect to his or her regional office and the offices of the provincial prosecutor within his region. And we have here the power and functions of the provincial and city prosecution offices: be the law officer of the province or city as the case may be, to investigate and or cause to be investigated all charges of crimes, misdemeanors, and violations of penal laws and ordinances within his or her respective jurisdictions, and have the necessary information or complaint prepared or made and filed against the persons accused, have charge of the prosecution of all crimes, misdemeanors, and violations of city or municipal ordinances in the courts at the province or city, and therein discharge all duties incident to the institution of criminal actions subject to the provisions of the second paragraph. And have here who is the head of the National Prosecution Service, and that's the Prosecutor General, who is formerly called as the Chief State Prosecutor. And here are the divisions of the NPS. We have the first one, the Inquest and Special Concerns Division. It basically conducts inquests and examines criminal complaints filed directly with the prosecutor's office. And this division is responsible for appearing the meetings called by the law enforcement agencies and related activities. Next is the PI and Prosecution Division. It is responsible, of course, for the conduct of investigation and prosecution of cases once they are filed with the Office of the Prosecutor General, or those cases filed under inquest proceedings. It has oversight over the proper conduct of PI and the prosecution of cases in courts. Next one is the Review and Appeals Division. It evaluates and reviews appeals made or petitions filed for review and final resolutions of prosecutors as described. And we have the Administrative Personnel Development and Support Services Division. It has as its mandate the conducting of investigations and preparing resolutions. One must say admin. May go back. One must say admin, Personal Development and Support Services Division. Basically, it handles career improvement and continuing legal education for the National Prosecution Service. Whereas this Disciplinary Field Operation and Special Concerns Division, this is they actually handles the conduct of investigation and preparing of resolutions on admin charges against prosecution and support staff. It coordinates and monitors the activities of the prosecution staff in different levels all over the country, and they're also involved in legal research and in the provision of opinions on the proposed legislation by the Department of Justice. And so, what is the doctrine of malicious prosecution? It is the doctrine that pertains to the prosecution through the misuse of abuse of judicial processes or the institution and pursuit of legal proceedings for the purpose of harassing, annoying, or vexing or injuring an innocent person. So, for instance, if someone knowingly provides false information leading to the unfounded arrest and prosecution of another, and the charges are later dismissed, the innocent party may have grounds to bring a lawsuit for malicious prosecution seeking redress for the harm caused by the misuse of a legal system. And how is prosecution of criminal offenses initiated in the Philippine setting? Well, for offenses that requires preliminary investigation, it's instituted by filing at the Office of the Public Prosecutor. Well, there are some certain cases, especially those involving more serious offenses, it requires a preliminary investigation before formal charges are filed in court. And the process begins with the filing of a complaint at the Office of the Public Prosecutor. During the preliminary investigation, the prosecutor evaluates the evidence to determine if there is sufficient basis to proceed with formal charges. And for the second one, for offenses that do not require preliminary investigation, the same shall be filed at the public prosecutor or filed directly with the court And the court that is being referred here is the Municipal Trial Court and Municipal Circuit Trial Court. So the explanation for this is that for less serious offenses or cases falling under the jurisdiction of MTC or MCTC, a preliminary investigation may not be required. And complaints for these cases can be filed directly with the public prosecutor. And for private crimes, the same cannot be instituted unless private offended gives consent or initiates the filing of the complaint against the offender, or in the absence or incapacity of the offender to initiate the filing of the complaint. So when we say private crimes, these are actually crimes that which cannot be prosecuted except upon complaint filed by the aggrieved party. So when it comes to private crimes, it requires the offended party's consent or initiation. So those offenses where the offended party is a private individual and not the state, typically it requires the initiation of the offended party to file a complaint. So in the absence or incapacity of the offended party, a representative or legal guardian may initiate the filing of the complaint. So we have right here some examples of private crimes. So we have adultery, concubinage, seduction, abduction, acts of lasciviousness. So also, we have to take note that for offenses wherein the penalty is less 1 year, regardless of crime, and the offender is not corporation, this will be instituted in Katarungang Pambarangay. So when we say Katarungang Pambarangay, this is a community-based dispute resolution mechanism in the Philippines. So the parties involved are encouraged to settle their differences with the assistance of barangay officials before pursuing formal legal actions. And what are the two modes of instituting criminal action? So we have complaint or information. So when we say complaint, it's actually a sworn written statement charging a person with an offense subscribed by the offended party, any peace officer, or other public officer charged with the enforcement of the law violated. The second one is the information. That is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. So just to set apart these two, complaint, this is being subscribed by either the peace officer, the offended party, or the aggrieved party, or any public officer. Whereas for information, it is the prosecutor who subscribed this one. And for the institution of criminal action, so criminal actions are instituted as follows. So for offenses where a PI is required pursuant to Section 1 of Rule 112 of the Rules of Court, it is through filing the complaint with the proper officer for the purpose of conducting the requisite PI. So I've discussed this previously, the second one. And for all other offenses, other than for those offenses where a PI is required, so you can file the complaint or information directly with the MTC and MCTC of the complaint with the Office of the Prosecutor, and in Manila and other chartered cities, the complaint shall be filed with the Office of the Prosecutor unless otherwise provided in their charters. So we have here the institution of the criminal action shall interrupt the running period of prescription of the offense charge unless otherwise provided in special laws. Because when we say prescription, it refers to the legal concept that sets a time limit within which legal action can be taken for a particular offense. So when I say prescription of crime, it is somewhat the offense have a limited period within which charges can be filed or legal proceedings are initiated. And once this period, known as the prescription period, expires, the state loses its right to prosecute the offender for that particular offense. So, for prescription of crime, so if it is punishable by death, reclusion perpetua, or reclusion temporal, the prescription of crime is 20 years. If it is a correctional penalty, with the exception of those punishable by arresto mio, for correctional penalty, that is 10 years. And for arresto mayor, that will be in 5 years. And also for the crime of libel or other similar offense, that shall prescribed in 1 year. And for oral defamation and slander by deed, that is 6 months. And for light offenses, that would be 2 months. And what is information? That we've discussed that previously. So an accusation in writing charging a person with an offense, subscribed by the prosecutor and filed in the court. So here are the elements of information. Of course, it should have the name of the accused, and this refers to the identification of the person or persons accused of committing the offense. Second one is the designation of the offense. What does it mean? It refers to the specific criminal offense or violations of a law that the accused is being charged with. The cause of the accusation. This section actually outlines the factual basis or circumstances that form the basis for the criminal action. So it presents a concise description of the events or actions that led to the charges being filed. And next one, it should have, or it should state as well, the place of the commission of the offense. So it specifies the location or venue where the alleged offense took place, and of course the date of the offense. So it indicates the date or time frame during which the alleged criminal act occurred, and the name of the offended party. So it refers to the identification of the person or entity who has allegedly been harmed or victimized by the criminal act. And is duplicity of the offense allowed? Well, the answer to this is no. Information must charge but one offense, except when the law prescribes a single punishment for various offenses. Is amendment or substitution of complaint prohibited? No. Information may be amended in form of in substance without leave of court at any time before the accused enters his plea. After the plea and during the trial, a formal amendment may only be made with leave of court, and when it can be done without causing a prejudice to the rights of the accused. So we all know that the information, it outlines the charges against an accused person, and it can be changed or corrected before the accused enters a plea, whether it is guilty, whether not guilty. And this change can involve adjustments to the wording or the substance of the charges and doesn't require the court's permission. However, once the accused has entered a plea and the trial has started, any formal changes to the information can only be made with the court's permission. And the court will allow such changes if they won't unfairly harm the accused person's rights during trial. So the main purpose of this is to ensure a fair legal process and protects the rights of the accused while allowing for necessary adjustments to legal documents. And we have right here the places where criminal action is instituted. The provided legal provisions basically outlines the location where a criminal case should be filed and tried. So we have here, subject to existing laws, the criminal action shall be instituted and tried in the court of the municipality or territory where the offense was committed or where any of its essential ingredients occurred. So, on this first statement, the general rule is that the criminal action should be initiated and conducted in the court of the municipality or territory where the offense took place or where any of its essential elements occurred. So, for example, if a theft occurred in, let us say, in Davao City, the case should be filed and tried in Davao City. Second one is where an offense is committed in a train, aircraft, or other public or private vehicle. While in the course of its trip, the criminal action shall be instituted and tried in the court of any municipality or territory where such train, aircraft, or other vehicle passed during such its trip, including the place of its departure and arrival. For this second statement, is situations where an offense happens in a moving vehicle, like what is stated here, the train, aircraft, or other public or private transport during its journey. The case can be filed and heard in the court of any municipality or territory the vehicle passed through during its trip. So this includes the location of departure and arrival. So for an instance, if a crime occurs on a train traveling from City A to City B, the case can be brought to court in any municipality or territory through which the train passed during its journey. Next one. Places where criminal action is instituted. So for letter C, where an offense is committed on board a vessel in the course of its voyage, the criminal action shall be instituted and tried in the court of the first port of entry or of any municipality or territory where the vessel passed during such voyage, subject to the generally accepted principles of international law. So let us say if the ship's first port of entry after leaving Manila is Batangas, the criminal case can be filed in the court of Batangas. Alternatively, if the ship passes through municipalities or territories like, let's say, Quezon, Mindoro, Davao during its journey, the case can be filed of any of these places where the offense occurred. For letter D, for crimes committed outside the Philippines, but punishable under Article 2 of the Revised Penal Code, shall be cognizable by the court where criminal action is first filed. So for crimes committed outside the Philippines, but those on Article 2 of the RPC, the case can be brought to the court where the criminal action is first filed in the country. So one of the Article 2 offenses there is mutilation of coins. So if a Filipino commits a crime in another country, such as the mutilation of coins, so that is covered by Article 2 of the Revised Penal Code, and the case can be filed in a Philippine court upon the offender's return to the Philippines. So who is being represented by the prosecutor in the prosecution of case? So the answer to this one, it's the public prosecutor. So for criminal prosecution, the public prosecutor represents the state or people of the Philippines. The offended party is a mere witness and a collateral, but the real offended party is the people of the Philippines, because crime is outrage and its vindication is in favor of the people of the Philippines.